May I please vote?
Yes.
Yes, Lordship, item number 5, Lordship, I may be allowed to withdraw, Lordship, with liberty, Lordship. The matter has been settled, amicably settled, Lordship.
Amicably settled.
Yes,
So why liberty then?
Lordship, just in case, Lordship.
Okay. Mr.
Thank.
Time.
And for the respondent.
Okay. Land Council for the petitioner submits that he has an instruction to withdraw this civil revision petition as the submit that the matter has amicably been settled between the parties and therefore the matter has become infructuous and hence prays for withdrawal of the petition. Mr. Tony Pardin, Land Council for the respondent has no objection. In view of the above and edge prays for Kama, the prayer is allowed. Stop. The civil revision petition is dismissed on as withdrawn. Okay.
Obliged.
May Your Lordship. Your Lordship, I beg to mention item number 25 on behalf of K. Tama, Your Lordship.
Item 25.
Yes, Your Lordship. This is with the concern of the other parties, Your Lordship. This matter may be fixed after 2 weeks, Your Lordship.
You're for the
Appellants
okay.
on
The consent.
on behalf of K. Tama, Your Lordship.
Ketama
Yes, Your Lordship.
obtain consent.
Yes, Your Lordship.
No. Have you? Who is for the other side?
Other side, I've already informed them.
Informed.
Yes.
Okay. Mr.
Jizring.
Sitting Land Council appearing on behalf of Mr. K. Tama, Land Council for the appellant, with the consent of the Land Council of the other side. Prays for listing this matter after when
2 weeks, Your Lordship.
after 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Highly alright. Your Honor, like to mention item number 26. I'm for the appellant. And due to some ill health, I could not prepare for a hearing. So kindly allow me for 4 weeks time.
You are for
I am for appellant. I'm SP Phukan.
appellant insurance company.
Yes, Your Honor.
What is the difficulties?
Actually, Your Honor, I'm suffering from neck pain
Okay.
since
You are Mr.
SP Phukan.
HP Phukan, Land Council for the appellant, submits that he has some personal difficulties to raise and therefore pray for adjournment of the matter. You have informed the other side.
Yes.
He has also informed the other side for other side, Land Council for the respondent, that he is seeking adjournment of the matter for the day stuff. In view of the above, the matter is then adjourned. List this matter after
4 weeks, Your Honor.
4 weeks. Okay.
Highly.
Lordship, I beg to mention item number 4. The leading counsel N. Rama is out of station, so this matter may be released after 3 weeks. And I have taken consent from the other party also.
Lordship, I am for respondent.
Okay. Mr.
Kitechi,
Your name is there.
not there in the
Submits
first
that
list.
the leading counsel, Mr. N. Rama, is out of station and therefore prays for adjournment of the matter, to which Mr. K. Porcelana counsel appearing on behalf of the respondent has no objection. Prayer allowed. List this matter after
3 weeks.
3 weeks. Okay.
Lordship,
Obliged.
I also would like to mention item number 19. The same leading counsel is out of station.
This is for order. Let us
Order,
see the
yes.
record.
This
We'll
the-
grant adjournment. Just wait for some time. Okay. See the record and pass necessary order.
Obliged.
Your Lordship, I take to mention the
Hmm?
item number 6, my lord.
Item 6.
On behalf of El Firme, consent has been taken from the other party. Matter may be listed after 3 weeks, my lord.
You are for
petitioner.
petitioner.
Oh.
And who's for the other side? Private respondent is also there?
Yes.
There is a stay in this case? Wait for some time. Okay.
Milad, I'm mentioning item number 7. The senior counsel is out of station, Mr. Tara. And I have obtained consent from the respective parties. Matter may be listed after 3 weeks, Your Lordship.
Okay, you are for the petitioner.
Yes, Your Lordship.
You are Mr.
P. Ronia.
Land Council for the petitioner. Some is, and some here on some is that his senior counsel is out of station.
Out of station.
They have to pray for adjournment. He has also informed the counsel for the other side.
Your Lordship, there's an interim order.
On the obtaining consent from the other side. Okay, please pray for comma. List is matter after
3 weeks, Your Lordship.
3 weeks. Stop. The interim order passed earlier shall continue till the next date of listing. Okay.
Oblige, Your
My lord, may I mention item number 28, my lord. My lord, most of the lawyers for the different accused persons are not available today, my lord. Some accommodation, even senior counsel, my lord, the assistant counsel for the High Court is also not available in this station, my lord. Today,
Ah.
my lord, some accommodation may be made in the month of, my lord, the December, second week of December, my lord. Subject to convenience of the
You are
party.
Yes, I'm
appearing
appearing on behalf of
party.
Empathy.
He's not there.
He is not in the station.
Okay, Mr.
Your Honor,
Anand,
Dates may be given after 12th of December. He is engaged till 12th of December.
Land Council for the, you are for respondent,
I am put a respondent number 1, my lord.
respondent number
1, my lord. Polan.
1. Seek accommodation. So, seek accommodation. For, how much time you said?
My lord,
For
second
the,
week
for
of
the day. Start.
subject to further.
Miss, you are Miss,
Diriba,
Land Council,
After 12th of December, my lord.
appearing on behalf of Mr. Mook Patin, Land National Advocate, standing counsel for the
20.
High Court, also made a similar prayer in view of the above.
Election.
The matter stand adjourned. And as prayed for the land council for the party, list this matter again on, when do you say?
22 December maybe.
20,
Yes,
okay, 28 December,
22.
22,
Yes.
okay, 22 December.
Development.
Item number 1.
Who is for the petitioner here? After some time, huh?
Item number 2.
May I please, Your Lordship? Lordship, this is an application under 483, Your Lordship, bail application whereby
Which one? Item?
2. Item number 2, Your Lordship,
Item number 2 is
bail application, Your
how
Lordship.
it has become bail application? In my cause list, it's a criminal petition.
Item number 1, Your Lordship, I'm so sorry. Got some mixed with. Yeah, no.
One.
I deeply apologize, Your Lordship. There was some miscommunication with regard to the item number.
Yes.
This is a bail application, Your Lordship, whereby the alleged accused has been arrested on 13/9/2025 in connection with Pasikat PS case 78 of 25, Your Lordship, under section 109.
Okay. So he was arrested on 13.
Yes, Your Lordship, 13/9/2025.
109
109, Your Lordship.
corresponding 307.
Yes.
Okay.
Attempt to murder. And then if Your Lordship would be pleased to see, page number 25 is the FIR, the type copy, Your Lordship. I may read, Your Lordship.
Okay.
I am to inform you that at around 11:15 hours, I received a mobile call from Sri Tagom Taki, my relative, that my husband Sri Anand Jamo has been admitted to BPGH Pasighat for cut injury. Accordingly, I met my husband at BPGH Pasighat, where he told that this morning, as per call from Srimati Pit Modi, who is the bail applicant, Your Lordship, she is the wife of the accused person.
Okay.
He went to 7 Mile Pasighat to see the land which was purchased by Srimati Pit Modi. My husband and Srimati Pit Modi were reportedly talking to each other when Sri Raj Ekut, that is the accused person, husband of Srimati Pit Modi, suddenly came and attacked my husband with a dao with an intention to kill. So that is the FIR.
We'll call for the case diary.
Yeah, Lordship, in this matter, it has been charge sheeted.
For charge sheeted.
Yes, Your Lordship. So in that case, if
Have you annexed?
no, this is after filing. We have not annexed the charge sheet, Your Lordship.
That was rejected earlier.
Yes, Your Lordship. Two of the bail applications.
On
that
what
was,
ground it was rejected?
The nature of the offense, Your Lordship, and that the intention that he might influence the witness. Those were the grounds, Your Lordship. Only considering that the section was 109, Your Lordship. Those two grounds.
Then since the status of the case has changed, why don't you apply bail application before the trial court?
Your Lordship, if Your Lordship will see the ground which we have filed, because one of the ground that was filed before the Sessions Court, that as per the Vivan, Your Lordship, that judgment, where the writing was not given with regard to the reasons for arrest, Your Lordship.
Okay, and here before this court, what ground you have taken?
That is also one of the ground with regard to the recent judgment, Your Lordship.
Okay.
Very recent judgment where it has been stated that.
Have you
that
annexed?
I have mentioned it in paragraph, Your Lordship, 16.
Have you annexed the arrest memo?
Yes, Your Lordship. I have
Where?
annexed. If Your Lordship will see, it's on page number 26, Your Lordship. And the type copy starts from 27. And it was on the same date. He was arrested on the date when the FIR was registered, and on the very same date he was produced before the judicial magistrate and then was remanded to the jail, Your Lordship, to the judicial custody. And it was done, everything was done on the very same date, that is 13/9/2025. In point number 6, Your Lordship, date and time of arrest.
Yeah.
Point number 6, 13/9/2025. And if Your Lordship will see page number 32, that is the forwarding of the arrest accused person, Your Lordship. The type copy will be in page number 34. The date, if Your Lordship will see, it's on the very same date, Your Lordship.
Whether this ground was considered?
No, Your Lordship.
So call for a trial court record.
Yes.
Lordship, if this matter can be fixed on 24th, Your Lordship.
Sure.
Monday.
Hard miss.
R. Taku, Your Lordship.
R. Taku, land counsel for the petitioner. Para. This application under section 482, 83 of the Bharatiya Nagarik Suraksha Sanhita 2023 has been filed by the petitioner praying for release of the accused Sri Rai Jokhio, namely Sri Rai Jokhio, who has been arrested on, who was arrested on 13/9/2025 in connection with the Pasigat PS case number 78/2025 under section 109 of Bharatiya Nyaya Sanhita 2023. Stop. After hearing now, R. Nishwenso and also Mr. G. Tadoha, plan additional PP for the state. Okay. Then in the below, Mr. Tado, Lanet ADA. Oh, you have, this is you who have submitted. Okay. It is submitted that the case is, after completion of investigation, the case has already been charged sheeted. So in view of the above call for the scanned copy of the trial court record. List this matter. Stop on Farah. Let's spread for list this matter. So it will be possible on 24.
24.
Today is,
Is it possible?
today is 20, so 4 days, because there will
Jana,
be a
scan copy?
Saturday and Sunday also, Saturday and Sunday.
Okay.
So it
Then
picks after
26.
26, Your Lordship.
Okay. 26.
Acha.
Item number 2.
May I, Lordship?
Yes.
Lordship, this petition is filed for quashing of FIR and GR case number 06 of 2024, which is pending before CJM Alo. Petitioner number 1 is the accused person, and petitioner number 2 is the complainant. Both the petitioners are immediate neighbor, Your Lordship, and there is some boundary dispute between them. And on 15 February 2024, there was some minor physical altercation occurred between the parties. And because of that, an FIR was lodged before Tirbin PS case, under PS case number 01/2024. The offense charged against the accused person, petitioner number 1, is of section 323 and 352 of IPC, Your Lordship. Both the sections are compoundable, and in fact, the matter has been settled between the parties on 15.
Both the offense
Yes,
registered against the accused applicant is compoundable.
compoundable.
Okay, then
And the settlement is also made between the parties.
then why you have come before this High Court?
Because, Your Lordship, after the settlement, kindly see page number 44. Parties jointly approach the Honorable Court of CJM Alo for referring the case before the National Lok Adalat. And considering the prayer, accordingly, the matter is referred to
Page 44.
page 44. This is the order of the CJM, Your Lordship. Matter is referred to the Lok Adalat. However, it is scheduled on 13th December 2025. And the problem here is petitioner number 2 will not be able to attend this Lok Adalat due to her urgent medical treatment. She is going outside Arunachal Pradesh, and her return is not is uncertain. So, and because of this reason, Your Lordship, the petitioner have approached this Honorable Court for urgent quashing of FIR and GR case. Your Lordship, petitioner number.
It's a compoundable.
Actually, Your Lordship,
Can-
petitioner
You have
1
come-
is
You have come under which provision?
528.
Okay, let us come to 528.
Your Lordship, because petitioner number is urgently require quashing of this case because he is intending to contest in this upcoming panchayat election, Your Lordship.
So
And
you want the
because of this pending case, he is unable to obtain police clearance certificate. Petitioner number 1 has tried to obtain police clearance certificate, but he has been issued police verification report, and it says that this FIR is registered and charge sheet is submitted. That's all, Your Lordship. So, Your Lordship, since these sections are also compoundable, my humble prayer is that Your Lordship maybe kindly dispose this petition today itself, Your Lordship, considering the urgency of the urgent requirement of the petitioner in the interest of justice, Your Lordship.
So that I think the politician can do. But then we have to follow the procedure. So can you,
No, it's
Yeah.
not maintainable per se, Your Lordship. Lordship will see.
it's a
first-
compoundable case.
Yes,
only.
it's firstly compoundable case. And since it's a compoundable case, since both the parties has approached the magistrate therein, and therefore it was sent to the Lok Adalat. Now, the process here is that the magistrate who has sent it to the Lok Adalat, if the parties does not settle therein, Your Lordship, then it can be reverted back to the same magistrate,
Yes.
then trial can proceed. And thereafter, if the parties seek and approach this honorable court, that would be a different case, Your Lordship. However, in this case, there are two issues, Your Lordship. Also, the fact that just to accommodate a person to, due to his negligence, Your Lordship, to accommodate under 528 and invoking the inherent power is, it does not even come to the process of abuse of the process of the court, Your Lordship.
Your Lordship, by the time it is settled in the magistrate.
Of the process of law here. Nothing.
Yes,
Mm.
Your Lordship, but by the
You
time
want
it is
you
settled,
want
it will
solution.
be delayed.
Solution from
Your
the High
Lordship.
Court, which is not possible. The High Court, the court has to follow the procedure. That kind of a solution probably is not available with the High Court.
Your Lordship, by the time it is settled in the magistrate, it will be delayed. Your Lord.
When the
petitioner won't be able-
when the FIR was lodged,
FIR was lodged on 16th February 2024.
24.
Yes, Your Lordship,
Okay.
and the
You wait for next election.
charge sheet was filed on 20 September 2024. This amicable settlement was made on 15 September 25.
Could have
Your
been
Lordship.
earlier. Charge is also filed earlier. Hmm? Well-
Your Lordship, settlement has been made recently.
That is why it is settled, already settled.
Yes, Your Lordship.
So under this 528, under what circumstances you can approach this High Court? Abuse the process, whether the process has been abused by anybody? You are aggrieved by action or inaction of anybody?
Your Lordship, my
Okay.
submission is based on the urgent requirement of petitioner number 1, Your Lordship.
Try and understand that solution, the High Court, how the High Court can give that solution. You are as submitting as if you are approaching the leader of the parties.
Only the police clearance certificate is yet to obtain, Your Lordship. That's why.
There we can't comment. Whether the police can give or not, we have no idea. But then he has not yet been convicted. To that effect, the certificate can be given. And then you can obtain a certificate from the court also regarding the present status of the case. And then you file affidavit or an application before the trial court. Because you say that case has already been settled between the parties.
Yes, Your Lordship.
And then she can at least file affidavit, sign affidavit using that affidavit, file application before the trial court for issuance of some certificate, which will be advantage for you. That a case, at least that detail can be given that the case has been settled between the parties, and if she can't, or if the trial court cannot issue the clearance certificate, at least that to that effect, that much certificate she can give, or he or she can give. Which
Yes,
court you said?
yes, Your Lordship, but
So-
before,
Before CGM Alo, Your Lordship.
For CJM Alo.
Lordship,
So what do you want? It's not maintainable. Better approach before the trial court. And if the trial court doesn't give any relief, despite of this, then you come back.
but before it is done, nomination will be completed.
You have
Your
to
Lordship,
face
that's,
what you have done. You have done where there is an allegation against you, and you kept silence for so since then, and then only when the election approach, probably you must have approached the informant.
If I may, Your Lordship, suggest
Mhm,
to my friend, Your Lordship,
mhm.
since the matter has been sent to the Lok Adalat on and which is to which will be sitting on 13/12/2025, Your Lordship. And prior to this order, the settlement was not done between the parties. Now, since the settlement has been done, Your Lordship, they can approach the Honorable Magistrate, the
Yes.
trial court and file an IA to recall back this order and subsequently file their settlement before the magistrate's court and get it compounded.
Let the present case refer to this.
A magistrate can always recall his order if there is some certain changes in the circumstances.
Now, this was on 13/12/2025.
that is the scheduled date for Lok Adalat, Your
For
Lordship.
scheduled date for Lok Adalat.
Yes, Your Lordship. Order was passed on 31 October 2025. And settlement was made in the month of September.
I think you have to, can make an application before the trial court. And then she can, the person to whom the heart is cold. Let them write application. I think you better you withdraw this application and make an application before the trial court, line a trial court. That since the party has already come into settlement, and then there is no grievances against the accused person, and then for this can be compounded by the person who had defamed or person whom the heart is caused. Then when the informant is ready, you can make an application before the trial court. And then inform that the case has already been, on the request of the parties, the case has already been fixed for Lok Adalat for settlement. But then inform the difficulties also, that urgent, showing the urgency.
Then, Your Lordship, may kindly reflect this.
No,
Or-
you have to withdraw this. No need to reflect. The court knows very well.
Okay, Your Lordship.
Okay. Mr.
Jilo.
Planning Council for the petitioner who wants to withdraw this criminal petition with liberty to approach the trial court. For appropriate relief. The prayer is allowed. This criminal petition stands dismissed on as withdrawn. Okay, with liberty is prayed. Okay, you approach.
Much obliged.
Item number 3.
May I, Lordship?
Hmm.
Lordship, we will file this is a joint petition filed by the petitioner number 1, that is alleged accused person, and petitioner number 2 is a complainant victim, Your Lordship. Lordship, this case has been pending before the CJM Pasighat, Your Lordship, arising out of FIR dated 10/1/2019, Your Lordship. May I please read the brief of the fact, Your Lordship?
Okay.
Lordship,
FIR was
on-
lodged by the petitioner number
petitioner number filed by the petitioner number 2, Your Lordship.
FIR.
FIR on page number 15, Your Lordship. Annexure 1.
Yes.
May I read the
Yes. We'd like to start.
Sir, I beg on dated 10/1/2019. I beg to inform you that on dated 10/1/2019 8 hours or 8 hours, so and so 1 Moge Tamogov Rani village came to my shop at Oyan Charali and attempted to assault with a sharp knife by demanding a sum of rupees 1,000 without any reason. He also threatened me last time on 7 January 2019 at around 7 p.m. and demanding 1,000 rupees without any loan. The incident was witnessed by many people. This was the FIR, and accordingly,
You are reading FIR.
yes, FIR. FIR, page number 17, Your Lordship.
Page 17.
Yes, a type copy.
Okay, what is application FIR against? Okay, there is 2 FIR.
Initially, there were 2 FIR, but only the one has been registered.
Okay.
And accordingly, the Oyan PS has registered a case.
Okay. Thereafter, case
Case has been, now the
Charge
case is,
sheeted.
yes, charge sheeted now,
against him under section 447.
yes.
Which one is non-compoundable?
Initially, they have been registered under section 447, 393, and 506. However, in the time of framing of charges, 511 has been added. Now the section 313 and 511 is non-compoundable, Your Lordship.
Okay. Now thereafter, what happened? Party settled.
Yeah, during the pendency of the
Process,
case, they have been
Which code you
settled.
said? Which code you said?
It is pending before CJM Pasighat, Your Lordship.
Pasighat.
Yes,
Process issued.
yes. And during the pendency of the case, they have been settled down.
Now,
Yes.
whether the CJM court issued the process.
Order form?
Charge framed.
Yes, the charge has
Okay.
already been framed, and now it is in the stage of PWS, Your Lordship.
Any witnesses examined?
Till date, no witnesses has been examined, Your Lordship, and for next date is
But the
on,
case has been settled.
yes, Your Lordship.
Yes. Can call for the record.
Yes.
Your Lordship, in the
Uh,
meantime, interim
Hard miss.
prayer and Hondik, Your Lordship.
And Hondik. Planning Council for the petitioner. I've also heard Mr. Jitado, non additional PP for the state staff para. This is an application filed under section 528 of BNS 2023, seeking setting aside and quashing of the proceeding of GR case number 09/2019 arising out of Oyan PS case number 02/2019 under section 447 for 393/506/511 of IPC. It is submitted that the case has been charge sheeted and a charge also framed against the accused. Applicant number. Who accused is applicant number?
Is
Accused
it
petitioner number
petition number 1?
1. Under section 386, read with 511. Charge frame.
Under section 447,
Okay,
39.
447,
yes,
386,
339, your lordship.
339.
Oh, sorry, 393.
Where
It is attempt to robbery.
charge frame under section
Section,
Space 40,
386.
386, 506, 511.
447, 386, read with 511, stroke 506 IPC. Call for the trial court, the court, list this matter. After, when? After a week, after a week.
your lordship, in the meantime, prayer for interim may be considered for stay of the proceeding, your lordship.
Considering that the matter has, considering that the matter has amicably been resolved by the parties, the further proceeding of the GR case number 09/2019 arising out of Oyan PS case number 02/2019 pending before the court of which court you said?
CGM Pasigad, your lordship.
Chief Judicial Magistrate Pasighat shall remain state till the next returnable date. Okay. Obliged.
Matter number 6.
You are for petitioner. And what about the respondent?
My lord, we have already taken consent.
Okay, for adjournment.
Yes, my lord.
Okay, I thought this is something. Okay, when do you want you said whether the respondent, they are the private respondent also? Yes. One private respondent? Not yet appeared. Informant. Now, your name is there? Okay, here is the case, informant might not appear. And this probably because there is no case, if the informant failed to turn before the court to give any evidence, and probably you'll be acquitted only. take advantage of that. I was trying to send it back. It's on merit only, the other side not appearing. And it appears there is not much case against you. Yeah, it involves other accused persons also. Not only you, isn't it? 4 or 5 persons are involved. And you are praying for only in respect of the present application petitioner. It will be difficult. Okay. But you are seeking adjournment today, Mister? So what is your ground for adjournment? Who is the council? Lising Parme? Parme is no, where is? Mister? Lana Council appearing? That is why it is affecting the other accused persons. Other accused person also would like to have the acquittal order, but then because of you, it's pending. Land Council, some said, the leading council, Mr. El Parme, is not before the court, not present in the court today. Therefore, pray for adjournment, to which the learned. PP has no objection. Prayer allowed. List this matter after a week. Okay.
Item number 8.
Yes.
This is first appeal challenging the order passed by the learned trial court, Chief Judicial Magistrate, Your Lordship. Why, the order that has been put to challenge is order dated
This is
28,
item 8.
Your Lordship.
Okay.
FAO, Your Lordship. This.
Mhm.
Now, the appellant that is before this honorable court has put to challenge the order dated 28/10/2025, whereby the learned trial court has rejected the plaint of the appellant, Your Lordship. So in this case, the appellant are the plaintiff, were the plaintiff before the trial court, Your Lordship. So they had filed a title suit number 12 of 25, along with an IA 44 of 25, Your Lordship, whereby they had challenged the formation of the coordination committee, Your Lordship. So now this is with regard to the plaintiff, that is the appellant. Your Lordship, he is the president of APCRCC.
What is that?
That is Arunachal Pradesh Christian Revival Committee, Council, Your Lordship. So he is the president of APCRCC. Now what happened here is a committee was formed without undermining the bylaws of the APCRCC. Since APCRCC is a registered society, Your Lordship, they are bound by the constitution and the bylaws of the APCRCC. Now, without considering the bylaws and the constitution of APCRCC, a coordinate committee was constituted. Then this coordinate committee has passed series of orders, Your Lordship. Now, what the president, that is the appellant before this honorable court, has filed the title suit for restraining the committee. Now, when there was this preliminary issues hearing, Your Lordship. Now, when the preliminary issues was heard, there were 5 issues that were placed, Your Lordship. Your Lordship will find that it's annexure 1, Your Lordship, page number 18. Lordship, may kindly see page number 18. And 19 is where the preliminary issues were mentioned. There were 5 preliminary issues, if I may read, Your Lordship. The first was whether the present suit is barred under order 23 rule 1 subclause 4 subclause B CPC on account of prior withdrawal of title suit 11/2025 on the same cause of action without liberty to file afresh. Second, whether the plaintiff has the locus standi to sue in his asserted capacity as president of APCRCC. Then third, whether the suit is maintainable as the APCRCC stood unregistered or its registration validity has expired on the date of institution, whether the suit is liable to fail for non-joinder of necessary party, whether the plaintiff disclosed infringement of a legally enforceable civil rights so as to disclose a cause of action, and if not, whether it is liable to be rejected under order 7 Rule 11, Your Lordship. Now, what happened if Your Lordship will see the entire plaint that was rejected was only basing on the order, the preliminary issue point number 1, Your Lordship, where the trial court has held that, just read the paragraph, page number 20, the second paragraph, Your Lordship, order 23, that starts with. Order 23, Rule 1, Subclause 4, Subclause B, CPC is explicit that where a plaintiff withdraws a suit without permission under Order 1, under Rule 1, Subclause 3, he shall be precluded from instituting a fresh suit in respect of the same subject matter. As the antecedent withdrawal was unconditional, the present suit is hit by the bar. The objection is sustained. Now, this is where the objection is sustained. Thus, suit is barred under Order 23, Rule 1, Subclause 4, Subclause B of CPC. Now, the entire order that has been passed by the learned trial court is basing on this issue number 1, Your Lordship. Because if I may not read, because the other issues 2, 3, 4, and 5, Your Lordship, it is clearly stating that because issue 1 sustains, so need not consider the other facts. Now, our prayer on the ground that is before this honorable court, we are stating that this order is wrong, Your Lordship. Why? Because if Your Lordship will see, first is the issue 1, 2, 3, 4, and 5 are the issues which are in violation of Order 14, Rule 2, Subclause 2 of the CPC. Because when an issue preliminary issue has to be considered, it clearly reads that it has to be basis on the law, Your Lordship. Now, these are the issues which has to be considered during the trial. And with regard to point issue number 1, Your Lordship, that says that it has been barred by 23, Your Lordship. If Your Lordship will see, that reads that if there exists a suit that was withdrawn without liberty, then it is barred by law. Whereas the title suit 12 of 25 was filed on 10/6/2025, and subsequently which the defendant stated that that was the earlier suit that was instituted, that is before the learned judicial magistrate junior division 11 of 25. That was filed on 11th, Your Lordship. So this suit has existed prior to the suit which has been withdrawn. Now, it's a very small matter, Your Lordship. So if I think they had filed a caveat and the copy has been served. Now, that is the main contention, Your Lordship.
Who else is the respondent? How many respondents are there?
Your Lordship, there's 12 respondents.
Well, you
Well-
are representing
I'm representing respondent number 12. 12, only 12.
Okay, what about the other
Uh,
respondents?
In this matter, Your Lordship, that my friend has only read
Okay.
one issues only, which I have in my written statement,
You represent only 12.
12, Your Lordship,
Caveat was filed by only 12,
12 only,
not by any other.
not by any
Okay,
other.
so
I was not authorized.
these 1 to 11 were not party in the earlier suit,
They were,
or
They were
in the suit.
yes.
So non-joined there because of this.
No,
That
Your
you
Lordship,
did not
this
include
1
that.
to 11, they were party of the suit, Your Lordship.
1 to 11 also.
Yes, 1 to 11. But since I think if they have not been represented, then a
Okay.
notice may be issued with regard to that, Your Lordship.
Miss?
Artaku,
Your
Your Lordship.
Lordship, otherwise Feroz- Your Lordship, may I?
What is, huh?
Your
You are caveator only?
Yes, yes.
What you want to submit now?
No, Your Lordship, just I want to clarify one thing. That
Hmm?
In section 96, what if they are coming before this court in form of regular past appeal? So that authority was made in environment in paragraph. It's because
That will, see later on.
they are
Okay.
challenging the order of civil judge senior division. They ought to have been filed before, appeal before district court under section 96. Then after, if they agree,
The impugn order was passed by,
civil judge senior division,
okay. The
Then
first
after-
appeal lies before,
before under section 96, lie before district judge. And then after, if they agree the district judge order, then only they can come before this court under section 100
Okay.
of second appeal. So otherwise, in,
okay.
notice may be
You
issued
you
to
raised
other parties.
objection? It was passed by the civil judge senior division.
Senior
Senior
division,
division.
your lordship.
You did not approach the district court.
Yes,
Your lordship, if your lordship will say this is from the original degree, then it can be filed before the Honorable High Court, your lordship, 96 if we read your lordship. Also along with, it is not just 96, that is also where it files subsequent, there is another order, 41 rule 1, your lordship.
it's only a memorandum only. Rule 41, order 41 rule 8. The appellant has remedies with them. They can approach before district judge.
Lordship,
Section
this
96.
point can be considered on the next
Yes,
day,
yes.
your lordship, correct?
Yes, yes, just,
Because as of now, the notice at least has to be
yes,
issued.
yes, that will do. Miss Taku, Taku,
Yes, your lordship.
Learned Counsel for the appellant. Start. Also had Mr.
Tabatokur.
T. Taku, Learned Counsel appearing on behalf of the respondent number 12, caveat of. Okay, start. Para. This appeal has been filed under section 96, read with order 41, rule 1 of the Code of Civil Procedure 1908. Selling the impugn order dated 28/10/2025 passed by the Civil Judge Senior, the Learned Court of Civil Judge Senior Division, Capital Complex, UPR, in title suit number 12/2025. Whereby the claimant of the appellant in title suit number 12, sorry, appellant has been rejected under order 7, rule 11D CPC. Holding that it is bar under order 23, Roman 23, Rule 1, within bracket 4, within bracket B, small b, CPC. Para. Issue notice. Call for the file code record. Stop. Since Mr. Taku, T Taku,
Tokur, T Tokur.
Tokur, you're Tokur. Land Council. Appeared and accepted notice on behalf of the respondent number 12, caveator. No formal notice need be issued to the said respondent. Start. The petitioner, sorry, the appellant shall take steps upon the rest of the respondents from respondent number 1 to 11 by a register post with AD as well as by usual process within a week from today. Start. This is matter after 4 weeks. Okay. And in the caveat,
Okay.
in the caveat,
A caveat can
Sin-
be disposed.
since Mr. Tokur was appeared and has been heard, the caveat stands discharged. Okay.
Okay.
Item number 9.
Lordship, we may be granted some more accommodation.
Yes,
Yes, Lordship.
this was to be admitted to
Another
the
party is also not here. This matter may be fixed on second week of January.
second week of January.
Yes, Lordship.
You are for
For the appellant, Lordship.
appellant. You are Miss Gao,
Yes, Lordship. Waigao.
Miss Yasmin Gao. Land counsel for the appellant. Praise for some accommodation. Seek for some accommodation for the and requested for listing this matter during
Second week of January, Lordship.
okay, after 4 weeks. Who is for the other side? Have you informed?
No, Lordship, they are not here.
Okay. No one appears on behalf of the respondent. In view of the above and as prayed for, list this matter after 4 weeks.
And Lordship, there's an interim
What was the interim?
to
It was
maintain,
only to maintain court
yes, status quo.
status quo. Okay. The interim order, if any, shall continue till the next date of listing. Okay.
Of Lordship.
Item number 10.
May I please, Your Lordship?
Yes.
Your Lordship, this is a regular bail application. Your Lordship.
May it please your Lordship. Lordship, on the last occasion, I was instructed to take a
Yes.
as to the status of the bail application, Your Lordship.
Status of
The bail application, Your Lordship.
bail application of
There was a bail application, Your Lordship, which was filed before the learned trial court, Your Lordship. Now, that matter, that bail application was subsequently posted on the next date when the main case was to be taken up, Your Lordship. Now, during the passing of the order in the main case, there was no reflection of if the bail was taken on that day or not, Your Lordship. Now, since we are not aware of the situation, if the bail therein was taken up on any occasion thereafter, Your Lordship, if that bail is pending or it has been disposed of, Your Lordship.
Your Lordship, bail application, bail rejection order is already available before this court. Your Lordship, I have confirmed with the registry. The bail application, they have forwarded the bail application before this court
Just
in the
a minute,
morning. It must be in the record.
Just a minute. Huh?
That-
No, it will be used to code, it's clear copy. No, is there any directions to?
I was directed on 13/11/2025, Your Lordship.
Okay, 1311
Yes, Your Lordship.
in the material.
Ija.
Okay, what is this information?
Yes,
Special, okay, you wrote this letter.
I had submitted a letter to the special judge, Your Lordship,
Over
to get the information. We have just received the information, the status of that bail application.
What is the reply?
The rejection of the bail order is in the
Oh, it's there.
record. It's there.
Bail order
It has
rejected.
come this morning.
Okay. Then, what is the bail was rejected on which date?
On 13/8.
13/8.
13/8.
13/8, yeah.
Okay, now trial of the,
The trial against the accused person is pending under section 21B of NDPS, which is an intermediate quantity.
okay,
Your Lordship,
So now-
Your Lordship, my humble submission is that records of 37 would not be applied in this case. And
okay,
which
but then the trial going on now,
trial going on,
charge framed against accused
charge
person?
frame.
Okay,
Earlier,
any prosecution witnesses
yes, Your
examined?
Lordship.
How many?
Yesterday expert was examined.
Okay, official expert, okay.
Yes. And next date,
Please.
for examination of the complainant is fixed on March 2025.
Okay,
Your Lordship,
now,
March
now
20
see, the fact of the case is known to the trial court now.
yes.
Earlier, it was rejected. Way back in the, it was in August. So now you can apply before the trial court.
Your Lordship may kindly come to the arrest memo, Your Lordship.
Hmm?
Arrest memo. Page 82. Your Lordship, at the time of arresting the accused person,
Hmm.
he was not being communicated with the ground of his arrest. And secondly, Your Lordship, in the checklist, Your Lordship, checklist annex 61. Your Lordship, there is no mention of ground of arrest, as well as in notice under section 15.
the ground of arrest is completely silent. Your Lordship, in this regard, Your Lordship, I have a latest judgment recently passed by the Supreme Court in B, BWM accident case.
So this page 61 is
Page 61 is checklist. The reason for arrest has been given, Your Lordship. Reason for arrest and ground for arrest are two different things, Your Lordship. This
is reason for arrest.
reason for arrest. These reasons generally apply to all the arrested person, but the ground of arrest is very specific, very personal.
What this citation says?
Your Lordship,
What is this about?
page number para 40.
Four zero.
4040. Your Lordship, I may be allowed to read out.
Just a minute. Para 40 is at page.
Page 16. 16 of 2022.
Yes.
The requirement of informing the arrested person the ground of arrest in the light of and under Article 22, Clause 1 of the Constitution of India. It is not a mere formality, but a mandatory binding constitutional safeguard which has been included in Part 3 of the Constitution under the head of fundamental rights. Thus, if a person is not informed of the ground of his arrest as soon as may be, it would amount to the violation of his fundamental right, thereby curtailing his right to life and personal liberty under Article 21 of the Constitution of India, rendering the arrest illegal. Another aspect which flows from the above decision and merit consideration is the mode of informing the ground of arrest to the accused person to effectively serve the intended purpose of Article 22, Clause 1 of the Constitution of India. This court has observed above had held that it would not be idle to read out the ground of arrest to a person who is arrested, as he may not be in the frame of mind to remember the content of ground that are read out to him. The court underscore that if the authorities are permitted to read out the ground and claim compliance with the constitutional and statutory mandate, the very purpose of the constitutional protection would be nugatory. As mentioned above, it has held while deciding the mode of communicating the ground of arrest so to serve the intent purpose of the constitutional mandate that the language used in the Article 22 Clause 1 and 22 Clause 5 regarding communication of the ground is identical, and therefore the interpretation of Article 22 Clause 5 shall ipso facto apply to Article 22 Clause 1. The ground of arrest must be furnished in writing in order to attain the true intended purpose of Article 22 Clause 1. The reference at this stage may be made to the constitutional bench judgment of this court in Hari Kishan Supra, wherein while dealing with the Article 22(5) of the Constitution of India in the context of the right of a detainee to be made aware of the ground of arrest, it has been held that the same should be furnished in a language which he can understand and in a script which he can read. If he is a literate person, the relevant portion thereof as are read. And your lordship, and your lordship,
But
Principal-
now you see, how long he has been inside?
8
Have you
months.
taken
your
this
lordship.
ground earlier?
No, your lordship, for the first time.
Yes.
Your lordship, another judgment I would like to rely, your lordship,
Oh.
recently passed by the principal bench
Regarding?
regarding ground of arrest in context of section 50 of
We
NDPS.
did not take this ground in the earlier bail application. Now you see the trial is at the verge of completion of the trial, the case.
Your lordship, on the earlier bail application, on merit, the bail application was filed.
Now you know that why you have been arrested.
Now, your lordship, therefore, your lordship, I was not arrested. The law says that the ground of arrest should be communicated before, before 2 hours, he produced before the
Now,
magistrate.
now at this stage, you know that why you have been arrested.
I know,
You have
I
been,
know the ground
framed
of arrest
charge
very
also.
lately, after 3
Explain,
months.
explain why you have been arrested, why you should be convicted.
Your lordship, as for the FIR,
Hmm.
I have been arrested for trafficking of drugs, for selling.
Hmm.
And for,
Now charge framed,
but the charge,
you were
those
given an
section has been
opportunity.
dropped out.
You have been asked that you have been charged under so and so. What do you have to say? Now you know.
Your lordship, that's what I know the ground of arrest very lately, but the constitutional says that it should,
What I'm saying is now you know, because at the time of framing of charge also you have been explained the charge against you.
yes, your lordship,
And you have given, you were given an opportunity to explain
yes, your lordship.
or what you say. So now at this stage, can this plea be taken
Yes,
when you know everything?
your lordship, the ground of arrest is to enable the accused to secure his bail, your lordship.
Now,
For-
no,
for
that was
3
not
months,
taken, no, that was not taken in the first stage.
for 3 months, your lordship, that's why I was not aware of the ground, the reason for my arrest.
What I'm saying is now you are aware
Now,
why you have been arrested. Now, will it be applicable?
yes, your lordship, it must be applicable because, your lordship, if the illegal itself.
Yes, Miss Jenny, what do you say?
Your lordship, I I would with this arrest memo, I would in fact state that
There is no, of course,
he has not provided.
it's
ground of
same,
arrest.
it's same.
It's same, your lordship.
But then at this stage, what I'm saying,
Yes,
at this stage, because in the first instance, in the first bail application, it was not his plea.
yes, yes.
Now at this stage, charge framed against him.
Yes.
Now prosecution witnesses examined. He was given an opportunity to cross-examine the prosecution witnesses also. At this stage, can he take this plea?
If I may, your lordship, since his arrest itself was not made in a proper way, your lordship, he can take this.
So on
plea-
that ground,
He can take this plea at any stage of the trial, your lordship.
I have no idea.
Absolutely, your lordship. In fact, just to, I have a very recent judgment of Mihir Rajesh Shah,
You have
Which
to,
was- which was passed in the month of November, your lordship.
Mhm.
This was more particularly taking into consideration all Bihan's Prasutya Pankaj Bansal's case,
Mhm.
your lordship,
Mhm.
where the court also kept in mind that if this continues, if
Mm.
such, because the ground of arrest has been, though it was discussed on the previous occasion, it has recently been discussed on many occasions, your lordship. If this is to be taken, it would open a Pandora box of all the accused coming out of the jail, your lordship. Now, therefore, when this order was passed,
Hmm.
The Honorable Court very clearly has stated that henceforth, this was in the month of November 2025, your lordship. Henceforth,
This was
Certain
arrested
rules-
in, this was this is April
April, your lordship,
2025, prior to passing of that
passing of
order.
that order. And while passing that order, it was very clearly mentioned that henceforth, even during the arrest, because there are situations where arrest is directly made, Your Lordship. If at that point of, because the police cannot keep on writing the ground of arrest and give it to the accused at that point of time, in fact, the Honorable Apex Court took that also into consideration and has passed an order that henceforth, even if the ground of arrest is not given at that point of time, Your Lordship, he may be arrested at point of time, but after, within a period of 2 hours, the ground of arrest has to be punished to him. It's not an immediate action, Your Lordship.
Where do we find that?
I have just passed
That
it
part?
since the court does not have a, Your Lordship, I'll just give the citation. Or otherwise, if Your Lordship just take up this case after some time, I'll bring the citation, Your Lordship. Because it discusses the entire citations which has dealt with the ground of arrest, Your Lordship. That would be
Okay.
much more.
Okay, that will help then.
Yes. If Your Lordship take up this matter
After some time?
after some time, Your Lordship.
All right.
Item number 11.
Lordship, my lord. The matter has come today, my lord. They are, public prosecutor was directed to produce the, my lord, scanned copy of the, my lord, TCR. My lord, lower court record, my lord. Because this is for the second time we approve this honorable court on the, my lord, change in circumstance that there was a charge sheet, but I was not charge sheeted. But still there is a continuous apprehension because my son,
You filed this application only after charge sheet has been filed,
yes.
but then where is the apprehension? Because you are
Apprehension is
not,
under paragraph, yes, paragraph 25 and 28.
you have not been implicated. You have not been implicated nor
I
been
was
charge
not
sheeted.
implicated, but my
Not
son
even
was
witness.
implicated.
Are you witness or here? What?
No, I was not even made a witness.
Not even a
My
witness.
son was, no, my lord.
Then what
Now
is the
the
ground for apprehension?
apprehension paragraph 25 and 28, I have specifically mentioned, because my son was now thought to be, my lord, apprehended. And in the guise of apprehension of son, police is every day coming and police is searching, my lord. And I got a letter from my wife also. The police came into my residence and police apprehended, my lord, both son and father. That was, my lord, the first, on the very
Then in
first
that
day of,
case, you can file bail application before the appropriate court.
no,
Page
Administrative
or para 24, para or page 25?
25 and 28,
Page 42.
42.
Page 42.
Page 42.
Yes.
Para 25.
Yes. Married.
Yes.
The petitioner states that it appears from the charge sheet that the investigating officer although excluded the petitioner and discharged him from the alleged offense by not submitting any charge sheet against him.
From the, just a minute, but discharge him. Although excluded the petitioner and discharge him from the allegation of.
By not submitting any
Yes,
charge
yes.
sheet against him for want of any incriminating materials, but the said investigating officer made remarks under the heading remarks of the charge sheet that accused procured firearms from militants so and supplied one pistol to accused Papa so and another to absconding accused Aman Dugi. Aman Dugi is my son. Now police is constantly, my lord, apprehending Aman Dugi. And in the guise of apprehension of Aman Dugi, my lord, police used to come to my residence.
You are
I am
Karan.
Karan Dugi. And that is my
You
apprehension.
are Karan. Aman is your
Yes,
son.
Aman is my son. Now they sought to, my lord, get Aman Dugi involved. On the other hand, the investigating officer made a statement in the charge sheet that the charge sheeted accused number 2, Biru Gunja Tamin, while disclosing the fact, admitted to have earlier supplied another pistol to Aman Dugi. The said investigation officer also made a statement in the charge sheet that the Aman Dugi is presently absconding. Thus, it admittedly appears that although the investigating officer didn't find any incriminating materials against the petitioner and thereby didn't send up him for prosecution, but made remarks that his son Amandugi is found to have purchased unlicensed pistol from charge-sheeted accused person Biru Gumja Tamin on the basis of statement made by the accused person under section 180 BNSS. The investigating officer, on the basis of the said statement of charge-sheeted accused Biru Gumja Tamin, started to apprehend the son of the petitioner, Sri Amandogi, alleging commission of alleged offense for purchasing the pistol from the accused person, but the son of the petitioner Amandogi is found absconding. The investigating officer in this regard also expressed the intention to submit supplementary charge sheet after obtaining prosecution sanction from the concerned district magistrate of Lower Subansri Giro under section 39 of the Arms Act 1959. The investigating officer, despite the discharge of the petitioner from commission of offense, continuously apprehended the petitioner. This is my statement, my lord. Therefore, my lord, Lordship may make an observation that there is no any question of apprehension once he was discharged from charge sheet. That sort of protection may be given because for 5828 is the in-hand power of the High Court. I praise God, my lord. Lot of power.
You approach the appropriate court in case of you being implicated in future. But here in this case, only on
Yes.
speculation, it will be difficult.
Then Lordship, speculation in the sense, my lord, Lordship then make an observation. That there is no any question on the part of the
This is a
investigating officer to apprehend the
premature on speculation.
No, my lord. what is the concern?
Your apprehension is speculative, isn't it?
My lord,
It
apprehension.
is speculative only.
Apprehension always be speculated. Apprehension always be
Hmm.
speculated. If I have the reason to believe, if I have the reason to apprehend, the language used in my lord 428 or my lord 438, the pre-requirement is the apprehension. Therefore, apprehension cannot be based on certain material. Apprehension is always on the basis of belief.
See, the case after filing of charge sheet,
My lord,
the IO has investigated, and on completion of the investigation only,
my lord,
the charge sheet was filed. And
lord.
you have not been implicated
my lord.
in the charge sheet. What more remains? What is the
Then
ground for?
Then
What
what
is
is
the
my
ground for
remedy?
apprehension? It's only a speculative only. That
Apprehension
even
is
after
always
submission
speculative, my
of
lord.
charge sheet against against other accused persons, still you are apprehension.
My lord,
You are
if investigating officer is used to come to my residence on a once a week in search of my lord,
you lose
my son.
complaint. You lose complaint. You lose
To whom?
complaint against the file FIR against the police officer who visit your house
No, no,
without
no, my
any
lord.
ground, without any reason. Because
Question
here
is, my
in
lord,
this
whether
case, it's end. The charge is already
whether
filed. You are not the
Lordship-
accused in that case.
Lordship may in that sense, in that
And
case,
if
Lordship may,
if the police is visiting your house for no reason, you file complaint for trespass.
no, I
Because it
cannot
is
go
not in
for my lord,
connection
any
with this
complaint against
case.
the police. Lordship may make an observation that if there is no any allegation against me or no materials against me, there is no any question on the part of the investigating officer
Okay,
to
okay. You
apprehend.
file FIR, then we'll make observation. You file FIR, we'll make observation.
No, what is the question to lodge an affair? How can I lodge an affair?
No, if there is nothing against you, still the police is disturbing you, then
My
it is
lord.
a trespass.
Then Lordship make an observation. Then I will dispose the matter within observation.
I have no idea. You have to make an allegation that police is visiting, even
Yes.
there is nothing against you, but still then the police is visiting. You make an FIR.
If I make a statement before the court on oath that this is happening, so why should not court take cognizance of that statement? Court is well, my lord, competent.
No. This is no. This court cannot in that way because the jurisdiction
Because-
falls under the
Because,
police.
my lord, what
Police,
is the
concerned police
basis-
station.
Right, my lord. I appreciate, my lord. What is the basis to exercise power under 480, my lord, 438 or present corresponding provision 528?
Yeah,
Court may-
let us just see once. Let us just see once 438.
Yes. 438 or 528, apprehension.
Yes,
I must have the
528.
reasonable apprehension.
Hmm?
If the apprehension is reasonable,
Apprehending
yes,
his arrest in connection with non-bailable offense.
my lord.
Okay, but
So this
here
is
is a case
non-variable offense,
where you
Yes.
earlier apprehended, but then
lord.
subsequently
my lord.
case already charge sheeted. The investigation ends there.
My
Case
lord,
already charge sheeted, and you are not the accused, not even the witness, not to talk of the accused.
my lord, I understand, my lord, I understand.
Where is the question of apprehension?
Then what is the legal impediment on the part of the court to make an observation that since there is no any apprehension on the part of the petitioner,
This is
therefore this
premature.
petition
This is premature. Clear. It's a
Lordship
premature.
may,
The application
may
is
make an observation.
premature.
Lordship may make an
Only,
observation. We don't find any my lord apprehension. That observation may be made. There is no any apprehension on trading of the on perusal of the entire bail petition. Therefore, it
It's
is
not.
premature.
Since it's a premature, it's
On
not
what count, my
maintainable.
Premature on what count? Premature in absence of any apprehension. So that part may be observed. That might be recorded.
Premature because
Premature.
you are not even a witness, not to talk of the accused in the case, where
Right,
the
my lord.
case has
Therefore,
already been charge sheeted, and then still you are apprehending. Where is the question of apprehending?
that's why I'm saying, my lord. If Lordship comes to the
Your
conclusion that
apprehension is speculative,
Lordship make an
and it is
observation.
premature. It's a
Lordship
premature.
make an observation that this petition is premature for want of apprehension. This much may be recorded.
Okay, that observation can be made.
Huh? Lordship may dispose
Premature
of the
for want of
matter.
apprehension.
Yes,
Hmm.
but on perusal of the entire pleadings, entire statement, court didn't find any apprehension.
Okay.
Therefore,
Okay.
court is
Hard,
this
Mr.
much
Hard,
be
Mr.
recorded.
A.K. Purkastia, Learned Counsel for the petitioner. Also hard, Mr. the lawyer, Learned PP for the state. The accused and the applicant filed this application under section 482 of BNSS 2023, apprehending his arrest in connection with the Itanagar Capital Complex PS case number 72/2025, registered under section 111 within bracket 2 within bracket small b stroke 3 stroke within bracket 6 and 3 section 3 within bracket 5 BNS. Oh no, only N 3 within bracket 5 BNS comma 2023 read with section 3 of unlawful activities within bracket Prevention Act 1967 and section 25 within bracket 1 within bracket 1 capital B within bracket small a stroke 27 within bracket 1 of the Arms Act. Whether earlier it was rejected.
Yes, yes.
Yes, Lordship.
Okay.
On the
Have you annexed? Have you annexed the earlier?
Yes, yes. My lord, at page 80,
Page
80.
80.
Answer 7.
That was the order passed by your lordship.
Oh.
18.
No, 80 is,
Sorry, my lord, sorry,
before,
sorry. It is,
order
my lord,
passed by the trial court. Trial
my
court,
lord,
it's 60.
Page 60
Page
also.
60. Sorry, my lord.
Mm.
Sorry.
So the trial court also rejected your bail.
That trial court, my lord, rejected, now granted the bail in connection with another case, interim bail. Later on, my
Okay,
lord, he didn't appear,
okay.
another case. Connected, my lord. At page 60, connection 1.
Yes, yes, yes. Mm. Wait, huh? Earlier it was rejected on what ground?
That was, my lord, my lord, PP, my lord, submitted that there are ample, my lord, materials against him.
Okay, para, huh? Earlier
Para 8.
by an order dated 16/6/2025, the bail application filed by the applicant under section 482 of BNSS 2023 was rejected. Stop, huh? And then rejected on the ground that considering the gravity of allegation
Yes, yes.
against it,
Involvement in illegal arms.
involvement in illegal arms trade, armed trade links to the militant group and the applicant's conduct evading arrest. In connection with the instant, in connection with the instant PS case 72/2025. Para.
In connection with my lord, Itanagar case number.
72.
Yeah, my lord. Yes.
Para. The Lana Council for the petitioner submits that there is a change in circumstances. As the case has already been submitted in the charge sheet.
Yes, 81. 83.
What is the observation made according to you?
Pardon, my lord?
However, while submitting charges, the investigating officer made a remarks under the heading within inverted comma remarks of the charge sheet that within inverted comma the accused procured firearms from a militant source within bracket Libemo P. Kitan, comma NSCN SKY bracket close and supplied one pistol to accused Tapa Nongno and another to absconding accused Aman Dugi. Inverted comma close stop. On the other hand, the investigating officer made a statement in the charge sheet that the charge sheeted accused number 2, Viru Gunza Tamin, while disclosing the fact, admitted to have earlier supplied another pistol to Aman Dugi. Stop. The said investigating officer also made a statement in the charge sheet that Aman Dugi is presently absconding. So how it is connected, Aman Dugi?
Aman Dugi is son of present petitioner.
Para. Where have you stated that there is a reasonable apprehension?
Para 25,
Para-
para 25. Page
42.
42. And relevant portion is about page 44.
It is further submitted that the investigating officer, despite the discharge of the petitioner from commission of offense, continuously apprehended the petitioner and his son, Aman Dugi. What is this? What apprehended? Continuously apprehended?
To the extent of raiding and searching the house of the petitioner at Itanagar.
Mm-hmm. No, what is this sentence? Commission of offense.
So, my lord,
Offense continuously apprehended the petitioner.
and his son.
What does it mean? What does it mean?
Or does the petitioner is sought to be, my lord, interrogated or sought to be, my lord, arrested or something else? Apprehension means arrest. Or apprehension means to put him into the, my lord, police custody.
No, you have said continuously apprehended. What
Apprehended by police is after him.
does it mean? Could you please just discharge of the petitioner from commission of offense?
Once he was discharged from commission of offense, there is no any question to apprehend. Despite that fact, police is apprehending. This is my lord, apprehension. This is my reasonable belief that anything might happen. And Lordship, if Lordship comes to the conclusion that there is no any apprehension,
Continuously
therefore,
apprehended the petitioner and his son Aman Dugi, even to the extent of raiding the. It's a troubling disturbance or what? Causing trouble?
yes,
You
yes,
mean to say
yes, yes,
continuously
yes.
disturbs the petitioner and his son Aman Dugi, even to the extent of raiding and searching the house of the petitioner at Itanagar. Therefore, the petitioner has sufficient reason to be apprehended by the investigating officer, and there is every possibility of or apprehension of being harassed in guise of apprehension of his son Aman Dugi. Hence this application seeking pre-arrest bail. Stop. Stop. Lanet PP Mr. Law submits. So what is your submission, Mr. Law?
He is not solicited.
Okay, submits that. Submits that the case after thorough investigation, the case has already been submitted into charges, and the accused and the applicant is
And even he.
not applicant is not the accused. He is not even the witness in the said case. Therefore, there is no question of apprehending his arrest in connection with the above PS case. Therefore, he submits that the present application is premature, mature, and not maintainable. Stefan, Kara. Okay, I'll conclude and then make some observation.
Yes, yes.
Make some observation. Okay, and disposal.
My,
Okay.
my lord, I'm not blood.
Item number 12.
Yes.
Yes,
Your Lordship, this AB has been filed in respect of Sagali.
yes.
This case number.
Take this also. BA. This is in which case? In earlier case, probably. What is this? CD in this case. This is also AB.
Yes, Your Lordship.
You are protected? No.
Yes, I have been given interim protection.
What is this, the allegation against accused? Just news. Where is the FIR?
Just this page number 14, Your Lordship.
Page 14.
14.
Oh, it's a long FIR.
3 page, Your Lordship. Marriage, Your Lordship.
Yes, from the body. It is to inform.
Yes. It is to inform you that I am a landlord where Arunachal Pradesh Rural Bank Sagali branch is functioning since 1891. I am to inform you that I had taken a loan amount of rupees 1,73,000 for Maruti car loan bearing registration number AR013121 from Arunachal Pradesh Rural Bank Sagali branch during the year 2011. So I was informed by the then branch manager, Mr. Neil Conwar, to open the passbook. So accordingly, I opened MTL 51 AC number so and so. I was advised to complete the monthly term loan within 36 months with effect from 18/9/2011 at the rate of 4850 as per the monthly terms. Point 1. I took Maruti car loan on dated 18 August 2011 on monthly term loan basis at rupees 4850. Subsequently, I had completed the payment of the said loan amount within 21 months, which was supposed to be completed within 36 months. The total payment of rupees 2,06,604 only was paid against the said Maruti car loan within 21 months. That the said loan MTL 51 was closed on dated 15/6/2013 after 1 year and 10 months of the payment of the said loan amount. Point 3. After closing the said Maruti car loan MTL 51 AC number so and so on dated 15/6/2013, the then bank manager Sri Milo Arun, the then BM APRB Sagali branch on dated 28/09/2022 directed rupees 6,354.
Okay, it's a long one.
Yes.
He had been protected by the interim order.
Yes.
What happened thereafter after obtaining interim anticipated bail?
Yes, he appeared before the IO, Your Lordship. He has
Okay.
submitted his statement, Your Lordship. Even
Okay.
otherwise, Your Lordship, in the entire FIR, Your Lordship, he's there is also an annexure of him being posted after the that particular incident
Okay,
of loan, Your Lordship. His only part played by him was that, which he has explained in his statement,
okay,
is that there was a pending due of loan of 1,70,000 something, which he had informed the applicant herein and he had paid it accordingly.
okay,
The allegation against him is only this.
okay. So
Later.
he was shown
He-
arrested.
He was shown arrested and he was
Released after.
subsequently released on bail.
Okay. Can matter absolute?
Yes, Your Lordship.
Had Mr. K. Daja, learned counsel for the petitioner. Also had Ms. Tijini, learned additional PP for the state. Stop. Para. By filing this application under section 482 of the Bharatiya Nagarik Suraksha Sanhita 2023, the petitioner seek grant of pre-arrest bail. The petitioner is seeking pre-arrest bail, apprehending his arrest in connection with the Sagali PS case number 28/2025 under section 318 within bracket 3/316 within bracket 4 PNS. Stop. Huh? On 11/11/2025, while calling for the case study, the applicant was protected by an interim anticipatory bail, directing him to release, directing that he be directing that in the event of his arrest, he be released on bail on furnishing a bail bond of rupees 15,000 with one surety of like amount, subject to the condition that he cooperate the investigating officer and make himself available for investigation, for examination. Stop. It is submitted that in compliance of the said direction, the accused applicant, the applicant appeared before the IO when?
On 15th, Your Lordship.
On
15th,
11/11/2022.
25.
2025. Stop. On his appearance, the applicant was arrested on the same day, arrested, and after completion of all formalities, including recording his police statement, the applicant was released on bail on execution of the bail bond on the same day. Stop. Huh? Para. Ms. Cheney, additional PP, basing on referring to the record, referring to the case study, submits that the accused, the applicant alleged accused stroke applicant has already given his police statement. He was arrested and subsequently released on bail. And he is cooperating with and thereby he is cooperating with the investigation of the case. And therefore, his custodial remand is no longer required. Para. In view of the above submission, it appears that the accused was arrested and subsequently released on bail. And since he is cooperating with the investigating officer, by giving his police statement and is ready to appear before him as and when called for, the interim, this court is opinion that not just leave that, the interim anticipatory bail granted to the accused on 11/11/2025 is hereby regularized and made absolute on the same terms and conditions. With the further condition that the applicant shall continue cooperating with for the further investigation of the case. This order shall be read along with the order dated 11/11/2025. Stop with the above, this bail application stands allowed and disposed of. Okay.
Thank you, Lordship. Degree of bless.
Return the case title.
Item number 13.
Yes.
My lord, the petitioner on several occasions that served the service report to the respondent number 1, but it is still awaited. So my humble request to the honorable court to issue a notice or direct to the concerned police institution to serve the service report to the respondent number 1.
Have you taken steps through the concerned jurisdictional police station?
Not yet. We have only we have taken this step with
Privately.
by registered post or 2 to 3 times we have served service report. But it's
There is a quasi petition.
yes, my lord.
How many respondents are there?
Respondent 2, man.
So this respondent number 1 and 2 are the informant.
Yes, my lord. They have complained against the petitioner on the trial court. So now here it is
What is the allegation against them?
allegation
against the petitioner. What is the allegation against the petitioner? Section 420. Okay. 419, 418. Okay. So, what about the respondent number 2?
both haven't,
Whether 2 appeared?
no, my lord.
2 also not appeared.
Yes, my lord. We have served
Respondent number 1 only.
number 1 and 2.
1 still awaited, not 2, 2 not reflected. What about the 2? Have you taken steps upon the respondent number 2 also?
Yes, my lord. Here,
Has taken
on-
steps. 1 only.
on 6
In the office notes.
November 2023,
What is that? Insufficient address. Yes, insufficient address. Insufficient address in both. You figure out. You ascertain the proper address. Full address. Take fresh steps. The address itself is insufficient. That is why. No, no, no. You have not mentioned any place. House number, nothing. When you say Nahalagan, where they will find? It's a big area. Even you mention the sector also, unless you mention the house number, street number. The Mr.
P. Roland.
Nana counsel for the petitioner
My
is
lord.
present. The office note
Hearing
dated 19/11/2025 reflect the service upon the respondents are still awaited. However, the no, just a minute. The office note reflect that the notice upon the respondent returned with the postal remark insufficient within inverted comma insufficient address RTS stuff. In view of the above, the Nana counsel for the petitioner prays for some time to take fresh steps upon the respondents after ascertaining the proper address, proper and full address of the respondents. Prayer aloud. Steps upon the respondent by a registered post with 80 within 2 weeks from today. Now, please this matter after 4 weeks. You ascertain the address first, proper address first. It's Nahalagan. You have mentioned some section, a sector. You have to ascertain the house and the street number, road number. Okay.
item number 14.
Yes.
Lordship, service report of respondent number 8 is still awaited, Lordship. I may be allowed to take fresh step, Lordship.
Okay. In view of the office note dated 19/11/2025, Mr.
G type.
Learned counsel for the petitioner prays for allowing him to take fresh steps upon the respondent number 8.
Yes, Lordship.
The prayer is enough. Steps for notice upon the respondent number 8 by a registered post with 80 as well as by user process within a week from today. Stop. This matter after 4 weeks.
4 weeks. Lordship, there is an interim order.
The interim order passed earlier shall continue till the next date of this thing. Okay.
Deeply of land.
Item number 15.
My lord, with regard to the item number 13, there is an infringement.
Okay, 13 also interim continue till next date. Okay. Yes,
This is a civil losing that is being, Your Lordship, and
still awaited service, still awaited.
we have to this console response.
So what do we do? You take fresh steps or wait? Fresh steps. Okay. Yes, your step taken early. Okay. Same order in view of the office no dated 19/11/2025. Miss
B memo,
P.
B memo.
Okay. B Mema, Lana Council for the petitioner. Praise for allowing her to take fresh steps upon the sole respondent. Prayer allowed. Steps upon the respondent. Step for service of notice upon the respondent by a register post with AD as well as by usual process within a week from today. Okay, this is matter after 4 weeks. Okay.
Item number 16.
The interim order passed earlier. There is interim.
Yes.
Shall continue till the next day of this thing. Okay. Yes.
My lord, we are yet to receive any instructions from the department, my lord. In regard to the prosecution sanction, my lord.
Regarding prosecution sanction.
Yes, my lord. In fact, my lord, earlier the prosecution sanction was issued from the state government. But the applicant being an IFS officer,
Okay.
the sanction has to be accorded from the central government.
Okay.
So we have returned to the central government and we are awaiting the prosecution sanction.
Okay.
What time we-
None appears on behalf of the petitioner. Stop, Mr. Ojing Opada, Laren SC, Standing Council ACB. Submits that he has written letter to the union.
Yes, my lord. The department has written to the union.
Department, okay,
Yes,
so the department has written a letter to whom?
To the Ministry of Forest and Environment,
The Ministry of Forest and Environment
my lord.
for granting projection sanction
My lord.
for, against accused, and the same is still awaited. Therefore, pray for some time. Prayer allowed. List this matter after 4 weeks.
My lord. Deeply obliged.
Item number 17.
My lordship,
Yes.
I may be allowed to phrase this for respondent number 2 and 3, or 1 and 2.
You are Mr.
BCO.
Lana Council for the appellant submits steps inadvertently. You have not yet taken steps.
Yes,
The
lordship.
step could not be taken upon the respondent number 1 and 2 and prays for some more time. Prayer allowed. Step for notice upon the respondent number 1 and 2 by a registered post with AD as well as by usual process within a week from today. Stop. List this matter after 4 weeks.
Deeply obliged.
Item number 18.
Yes. Yes.
My lord, I am for the sole respondent, my lord.
Okay.
Mr.
So this is IA is for what?
IA is for condonation of delay.
Okay. You have objection.
Yes, oh yeah, I have already filed.
Okay.
then,
Objection.
yes, objection.
Okay.
and,
Then on behalf of the petitioner, Mr. Opada, Planning Council for the sole respondent.
My lord,
Some Mr. When it was filed.
it was filed, my lord.
Okay. So he was to file affidavit in
Yes,
reply.
yes, my lord.
Okay.
30th of June.
Okay.
Sonsar was supposed to file his
Sami
reply.
said, he has filed affidavit, he has filed objection. However, the applicant was to file affidavit in reply. However, the applicant is yet to file affidavit in reply. So in view of the above, let this matter be listed after 3 weeks.
My lord. In fact, there is a delay of 2,555.
Oh, then that's too much.
Therefore, I have,
Okay.
otherwise, it was not.
What is this matter otherwise?
Otherwise, it's a civil revision, my lord.
Civil revision?
Yes, my lord.
Okay.
Leave your.
Item number 19.
My lord, in this matter,
Oh,
I'm
you
entering
prefer-
appearance on behalf of some of the respondents.
Hmm?
Some of the respondents, respondent number 4, 3, 4, 5.
Someone came for adjournment.
Yes, Lordship. This morning, yeah,
Okay, okay. You were praying for adjournment.
yes.
So since you are for,
I'm appearing on behalf of respondent number 3, 4, 5, 6, 8,
Okay.
9, 12.
he is seeking for adjournment.
Anyway, my lord,
No.
my presence might kindly
Okay.
recorded.
Mr.
Titechi.
Land Council for the petitioner. Sorry. Mrs. H. Sami said, Rama is out of station.
Yes,
Sami said the leading counsel, Mr. N. Rama is out of station, therefore prays for adjournment of the matter. To which Mr. Dilaji, Land Council appearing on behalf of on behalf of respondent number.
3, 4, 5, 6,
Okay, 3, 4,
8,
5,
9,
6, 8, 9,
12,
Okay.
13,
12,
14,
13,
15, 16.
14, 15, and 16. Before that, El Hage, for the state respondent, and Mr. Dilaji for Sohn has no objection. Accordingly, the adjournment prayer is, the prayer for adjournment is allowed. This is matter after 4 weeks,
3 weeks.
3 weeks. Okay.
Much obvious.
Item number 20.
May I please, my lord?
Yes.
My lord, I have filed one interlocutory application for a restoration of interim order, lordship, that was passed on 26/6/2025. Lordship, what did happen on this honorable court?
Interlocutory application number
This is 105, lordship,
105 is for what?
for a continuation of interim order dated 26/6/2025.
Okay, there was a stay.
Yes, lordship. However, subsequently, initially, stay was granted on 26/6/2025.
Mhm.
Thereafter, on this matter was listed on 4/7/2025.
Mhm.
So, the respondent number 2
This
has,
criminal petition, this is
yes,
quashing
criminal,
petition,
yes, criminal petition,
quashing petition, for
lordship,
quashing.
lordship, quashing of FIR, lordship.
Okay, just a minute. So there was a stay
Yes, lordship.
by an order dated 26/6.
6, lordship.
By that order, it was
The further
Okay,
proceeding
FIR.
of FIR was stayed. Operative portion is,
proceeding in the FIR means it was still in investigation stage.
lordship. The reason for grant of stay, lordship, basically this is a civil dispute, lordship, between the two parties. So if I may take lordship to the factual background of this case, lordship.
No, just a minute. Yes, Lana PP, what is the, well, thereafter, whether the investigation continued, carried out?
No, lordship. After state,
Okay. What is the allegation? Just let us see the FIR then,
FIR, lordship, is in
page 35.
page, yes, 35, lordship.
Criminal conspiracy,
Yes,
misappropriation,
lordship.
breach of trust,
Lordship.
forgery, cheating. Misrepresentation also.
Lordship. That is the allegation, lordship.
Hmm. Hmm. In short, what is the allegation?
Lordship, basically,
How it is a civil case?
Lordship, what it happened, the allegation here is criminal conspiracy, misrepresentation, criminal breach of trust, forgery, cheating. So there's various allegations against the instant petitioner. However, Lordship, the factual background of the case is initially petitioner number one, who is a consultant, who is a consultant. So he was approached by respondent number two. He was approached that whether he has he has some works or he can provide some work. So considering the request made by the informant, he has contacted, petitioner number one has contacted a private company.
Anyway, whether have you received the record? Whether case diary was called for? If it was not proceeded, then what? How it was?
We didn't receive lost case data.
Whether it was called for? Because it was stayed only, not proceeded.
Lordship. Here, Lordship, the allegation was that these particular persons, they have misrepresented them by entering into a contract agreement where the work was yet to be awarded. That was the allegation. They have not presented the entire fact. What it happened, Lordship? Initially, there was an agreement between between the informant and the alleged accused person with regards to construction of certain building.
Okay, anyway, so can be extended.
Yes.
Okay.
Since this is the extension of Lordship. In other also Lordship, in page number 38, Lordship, annexure to when granting the interim bail, the learned trade could also observe that this is civil nature.
Okay.
Is it
Okay.
number 39,
Okay.
Lordship?
Hard, Mr.
A Tatak.
A.
Tatak.
Tatak, Planning Council for the applicant stroke petitioner. Also heard Mr. Loy for the Lana PP for the state and Mr. N.
NED.
ED for respondent number 2. Stop, para. By an order dated 26/6/2025. This court, while issuing notice upon the respondents, has directed that the further proceeding of the FIR dated 19/3/2025 be stayed till the next returnable date. However, the same was not continued thereafter. By this application, by filing this application, the applicant petitioner prays for continuation of the interim order the Lana PP interim order and some interim order stuff. He further submits that, and then leave it. The Lana PP as well as the Lana Council appearing on behalf of the respondent has no objection. Accordingly, the prayer is allowed. The interim order passed on 26/6/2025 in criminal petition 136 AP 2025 shall continue till the next date of date of listing. Okay. Oh, just a minute. With the above this, I stands disposed of. Okay. And in main, main same, are Mr. So-and-so and Mr. Loy also, and private respondent also. Okay. Mr. It is submitted that the for proper adjudication of the matter, the case diary would be necessary. Accordingly, call for the scanned copy of the case diary. Is case diary only? Yes. Okay. List. Till the can list this matter after 2 weeks. Stop. Till then, the interim order passed earlier shall continue. Okay. The interim order passed earlier shall continue till the next date of listing. Okay.
Deeply applied.
Item number 10 is a password for the timely matter.
10.
I'm placing two judgments of the apex court, Your Lordship. Your Lordship will first take up the state of Karnataka versus Sri Darshan. Lordship will see this judgment was passed on 14/8/2025, Your Lordship.
Yes.
If I may take Your Lordship to the page 3, Your Lordship. The down below is the page number.
Yes.
Paragraph 4.
Yes.
If I may read, Your Lordship. During the course of investigation, accused numbers 1, 2, 11, 12, and 14 were arrested on so-and-so date, while accused numbers 6 and 7 were arrested on so-and-so date. All the arrested accused were remanded to judicial custody. Upon completion of the investigation, a total of 17 persons were implicated as accused, and charge sheet along with 2 supplementary charge sheets was filed before the jurisdictional police station. Now, in this case, Your Lordship, the charge was framed and the cognizance was taken, Your Lordship. During the taking of the cognizance, the applicant herein had filed for the bail, and one of the ground for the bail was that he was not given an proper explanation for the ground of arrest. Now, if I may take Your Lordship to the observation of the Honorable Court, at page number 18, Your Lordship.
Yes.
Now, my relevant paragraph is at page number 19, paragraph 20.1.7, Your Lordship. If I may read, Your Lordship.
Yes.
In the present case, the arrest memos and remand records clearly reflect that the respondents were aware of the reason for their arrest. They were legally represented from the outset and applied for bail shortly after arrest, evidencing an immediate and informed understanding of the accusation. No material has been placed on record to establish that any prejudice was caused due to alleged procedural lapse. In the absence of demonstrable prejudice, such as irregularities, at best as a curable defect and cannot by itself warrant release on bail. As reiterated above, the High Court treated it as a determinative factor while overlooking the gravity of the charge under Section 302 IPC and existence of a prima facie case. Its reliance on Pankaj Bansal and Prabir Purkastaya is misplaced as those decision turned on material different fact and statutory context. The approach adopted here is inconsistent with the settled principle that procedural lapses in punishing ground of arrest absent prejudice do not ipso facto render custody illegal or entitle the accused to bail. Now, if I may elaborate this paragraph, Your Lordship. Your Lordship, there are the two major point has been taken, Your Lordship. First, even if the ground of arrest is not given at very initial point of time, Your Lordship, subsequently, when the remand is made before the magistrate, Your Lordship, there the police always give the reason and the ground before the magistrate that he has to be kept on so and so. He has to remanded to the police custody for so and so period for this reason, Your Lordship. Now that reason was already recorded in this case, particularly, Your Lordship, in the remand order, Your Lordship. Now the court, while taking into consideration that even if the ground of arrest was not given by the police at initial point of time, it was already recorded in the remand order, Your Lordship. Now in the remand order, subsequently, Your Lordship, since there was a reflection, Your Lordship, there was, and subsequently the applicant has also immediately thereafter filed a bail application, Your Lordship. That filing of the bail application itself clearly shows that he had the knowledge about the ground of arrest, and therefore they had come before the court at the very initial for the bail, Your Lordship. Now, taking into consideration even if ground of arrest was not given by the police at the initial stage, it was recorded in the remand order as well as the immediate filing of the bail application, implementing that they were well aware of the ground of arrest. And therefore, though this ground was one of the ground where the Honorable High Court has given a bail, Your Lordship, the apex court, while reputing while going in against, Your Lordship, has in this particular paragraphs come to a conclusion that even in Purkastaya's case, Your Lordship, the facts was totally different, Your Lordship. However, in this case, Your Lordship, they were well aware of the ground of arrest, Your Lordship. This was passed in 14/8/2025, Your Lordship. Now, if I may take, Your Lordship, to another case, which is of very
No,
recent.
here you are against or for?
I'm against because if Your Lordship is
Now you are coming against.
against, I have gone through it and I'll explain
right.
explain why against, because Your Lordship's question basically was that
Yes, that
at
is
this stage, Your Lordship. Now, in case of Darshan, Your Lordship, therefore I had come to that particular paragraph that subsequent to filing of the charge sheet, Your Lordship, the trial started, and at this stage of trial, Your Lordship, they had come before the court for the bail. Now, during taking into consideration the entire fact and the process of the submission of the charge sheet and the process of proceeding of the trial, Your Lordship, during that period when the bail was entertained by the Honorable High Court and the bail was granted, this is one of the ground was that the reason of the ground of arrest was not taken. And at that point of time, the Honorable Apex Court, while going through the records, has come across and has stated that even if the ground of arrest is not given immediately, the subsequent remand made by the police clearly shows that the reason as well as the ground of arrest before the magistrate seeking for remand of the accused, Your Lordship. Now, reflection of the same in the remand order and subsequently the filing of the bail, because any person without he having a knowledge of his own case and the reason why he is arrested would not come before the Honorable Court for the bail. And that was the 2 point taken by the Honorable Apex Court while cancelling his bail, Your Lordship. Now, if I may take, I'll just make it clear, if I may take, Your Lordship, to another case, which is Mihir Rajesh Shah, Your Lordship. And more particularly, I would take, Your Lordship, to page number 42, Your Lordship. I'll start with paragraph 47, Your Lordship. It would not be out of context now to refer to an obligation which has been imposed on a person making arrest as provided under Section 50A read in relation to Section 50 of CRPC 1973. now section 48 and 47 of BNS 2023 to inform the arrestee of his right to indicate his relative, friends or such person for the purpose of giving information with regard to his arrest. Simultaneously, a duty has also been cast on the person making arrest to forthwith thereafter inform of such arrest with reasons and the place where the arrested person is being held to the indicated person. The police officer making any arrest shall make an entry of the fact as to who has been informed of such an arrest in a book to be kept in the police station. Further protection in this regard is reflected when a duty has been cast on the magistrate to satisfy himself when the arrestee is produced before him that the above requirement stands complied with. This requirement is in addition to the right of an arrestee to be made aware of the ground of arrest. Now, Your Lordship, as I have already stated, Your Lordship, immediately if the ground of arrest is not given by the police, or even if the ground of arrest is being given by the police, the next step is the production of the accused before the magistrate. Now, there is a permission always sought for magistrate for either his remand to the police custody or to the judicial custody. It's a duty of the magistrate to see if the ground of arrest has been taken, and while applying his judicial mind, he will decide on if the ground given by the police is genuine and if the prayer for remand of the accused is necessary, Your Lordship. Paragraph 48, Your Lordship. The second issue which requires a consideration is when grounds of arrest are not furnished either prior to arrest or immediately after arrest, would it vitiate the arrest for non-compliance of the provision of section 50 of CRPC 1973? Irrespective of certain exigencies where furnishing such ground would not be possible forthwith, it is by now settled that if the ground of arrest are not furnished to the arrestee in writing, this non-compliance will result in breach of constitutional and statutory safeguard, hence rendering the arrest and the remand illegal, and person will be entitled to set at liberty. Now, this is the answer to Your Lordship's query, Your Lordship. If I may read once again, Your Lordship.
Yes.
It is by now settled that if the ground of arrest are not furnished to the arrestee in writing, this non-compliance will result in breach of constitutional and statutory safeguard, hence rendering the arrest and remand illegal, and person will be entitled to be set at liberty. Now, this ground of arrest, the ground for bail on the ground of arrest is only limited to the arrest and remand, Your Lordship, at that point of time. Now, if I may substantiate my this statement, which then Your Lordship will come to page number 46, Your Lordship. Paragraph 52, Your Lordship. We thus hold that in case where the police are already in possession of the document material furnishing a cogent basis for the arrest, the written ground of arrest must be furnished to the arrestee on his arrest. However, in exceptional circumstances such as offense against body or property committed in flagrant delicto, where informing the ground of arrest in writing on arrest is rendered impractical, it shall be sufficient for the police officer or other person making the arrest to orally convey the same to the person at the time of arrest. Later, a written copy of the ground of arrest must be supplied to the arrested person within a reasonable time, and in no event later than 2 hours prior to production of the arrestee before the magistrate for remand. The remand paper shall contain the ground of arrest, and in case there is delay in supply thereof, and not indicating a cause for it to be included for the information of the magistrate. Now, Your Lordship will see that ground of arrest is not only limited to the police or the investigation officer, Your Lordship. Even the remand order, there was a case, I'm not able to find it now. There was also a case of the Apex Court where the ground of arrest was not reflected in the arrest memo. However, the same was reflected in the remand order, Your Lordship. And therefore, the Honorable Apex Court, even in that case, had come to a conclusion that the ground was very much apparently given to the accused, Your Lordship. Now, this is the case I was referring to, Your Lordship. If Your Lordship see the guidelines framed by the Honorable Apex Court at page number 48, paragraph 56, Your Lordship. In conclusion, it is held that the constitutional mandate of informing the arrestee the ground of arrest is mandated in all offense under all statutes, including offense under IPC 1816, now BNS 2023. The grounds of arrest must be communicated in writing to the arrestee in the language he or she understands. In case where the arresting officer person is unable to communicate the ground of arrest in writing or on or soon after arrest, it be done orally. The said grounds be communicated in writing within a reasonable time, and in any case, at least 2 hours prior to production of the arrestee for remand proceeding before the magistrate. In case of non-compliance of the above, the arrest and subsequent remand would be rendered illegal and the person will be at liberty to set free. Your Lordship.
Your Lordship, my case is that, Your Lordship,
Let me finish. Now, if I may take Your Lordship to page number 50, Your Lordship. Paragraph 58. We are cognizant that there existed no consistent or binding requirement mandating written communication of the ground of arrest for all offences. Holding as above, in our view, would ensure implementation of the constitutional right provided to an arrestee as engrafted under Article 22 of the Constitution of India in an effective manner. Such clarity and obligation would avoid uncertainty in administration of criminal justice. The ends of fairness and legal discipline therefore demands that this procedure, as affirmed above, shall govern arrest henceforth, Your Lordship.
Okay, then,
Now, yes, now my only submission, I otherwise leave it to the wisdom of Your Lordship, but then my only, the query was put that if this ground of arrest would be a ground for bail during the trial, Your Lordship, when the charge, the cognizance has been taken and the trial is in proceeding, Your Lordship. Your Lordship is also well aware of the Apex Court order in X versus the state of Rajasthan, which clearly says that when the trial is in proceeding, Your Lordship, normally the court should not be hasty in giving bail, Your Lordship. Now, while submitting these two case, Your Lordship, my only humble submission is that in terms of ground of arrest, the ground seeking for bail on the ground of arrest would, as per my understanding after going through both these judgments, are that it would be confined only during the arrest at the initial period of investigation and only during the remand period, Your Lordship, not subsequently, Your Lordship. Because during this time, as already reflected in Darshan's case, Your Lordship, during this time, even if the remand orders also have any reflection of ground of arrest or the subsequent bail application filed by the applicant, Your Lordship, would clearly
same
establish.
case, whether at the time of remand,
Yes,
so this is reflected,
yes. Even
ground for his arrest.
yes, even if there is a reflection not in the arrest memo, but even in on the remand. Your Lordship.
Your some more to submit?
yes, Your Lordship.
Okay, then we'll, what we'll do. This is item 10, okay. I think, we'll get in listed tomorrow then.
Yes.
Okay, you also come prepared. She has given, earlier she was supporting, now, now, I think she has realized,
Your Lordship,
and then you have to counteract, okay?
yes.
So, as prayed for by the Lani Council for the petitioner,
Your Lordship,
let this matter be listed again.
my humble request is that, Your Lordship, tomorrow, along with the ground of arrest, my other ground may be also considered, Your Lordship.
Okay, you bring it, okay? This, okay, tomorrow, huh? Okay. So the rest will continue at 2. Yes,
This item number 21 will be listed after 1 week.
after
1 week.
1 week. Ms. Y. Gao, Lani Council for the petitioner, prays for listing this matter after a week. Mr. Kudu, you are, yeah.
Yes, madam.
And
For
2 weeks,
resolution number
Mr.
1,
Kudu, Lani Council for the
SIT, madam.
SIT. Lani Steering Council for the SIT has no objection, according the prayer is allowed.
And
List
madam,
this
PCR
matter
is still
after a week.
awaited, madam.
Hmm?
PCR is still awaited.
Oh, it's still awaited?
Yes,
Then 2 weeks.
2 weeks, madam.
No,
Okay.
Lordship, 1 week.
Trial court record.
Yes, madam.
Yes, Lordship.
Where, which court?
JMFC UPA.
Yeah, then 1 week, I think.
Yes, Lordship, 1.
Okay, the trial court record, which is still awaited in view of the, the trial court record is also still awaited. list this matter after a
And my lord,
week.
service-
Okay?
service
You
again
should
was-
remind that for the trial court record. Scan copy of the trial court record. Okay? Yes.
Service against respondent number 2 is also awaited.
Is it?
Yes.
Then what's the point of listing it, getting listed next week? Still, service is still awaited.
Lord,
We have to
if
complete that.
Service is complete within this 1 week.
Okay, then, okay, it's fine. Okay.
And my lord, registry may be directed to
Remind the arrested.
reflect my name. It's,
Yes, okay. The registry shall reflect the name of Mr. Kudu as standing counsel for the SIC in the court list. Okay.
Obliged, Lordship.
Obliged.
Hmm.
Item number 22.
Your Lordship, in this matter, this case has already been charge sheeted on 1/10/2025, Your Lordship.
Okay.
Lordship, we have filed this criminal petition for crossing of FIR.
Okay, we have earlier called for case diary.
Yes, Your Lordship.
Now, trial court record is to be called for.
Yes, Your Lordship. Also, since only in the FIR, only section 420 and 406 was included, Your Lordship. However, when the charge sheet was filed, 506 IPC was also inserted, Your Lordship.
Okay.
If I may, Your Lordship, if we can challenge the charge sheet because 506 is also now included in the charge sheet, Your Lordship.
Now it's in not a joint petition. It's on
No, Your Lordship.
merit.
Only on merit.
Then yes, I think 506.
506 is also included.
Now in the charge sheet, 506 is also included. Yeah, I think you have to include and new challenge.
Lordship, so I may be allowed to file IA to bring in record for the passing of FIR and charge sheet.
Amendment. Oh, amendment of the
They can file an IA, also bring into the entire contents of the charge sheet otherwise, Your Lordship.
right. Hmm. Mistake in an additional PP for the state. Some is that during the pendency of this criminal petition, the case has already been submitted into charge sheet against a accused petitioner for offense under section. No, against the petitioner under section for commission of alleged offense under section 420, 460, 460 and 506.
506, Your Lordship.
Okay. Before the, which court?
This is before this CGM, Your Lordship.
Before the chief judicial
UPA.
magistrate. UPA?
UPA, Your Lordship.
Papumpare, district UPA. Chief judicial magistrate is Papumpare or?
UPA, Your Lordship.
UPA is under Papumpare?
Capital
or-
Complex.
Oh, capital complex, okay. UPA. Staff. In view of that, Ms. D. Rilong, Lani Council for the petitioner, praised for allowing her to amend the petition by way of filing additional affidavit. Additional.
Your Lordship can,
It's
IA would be much appropriate because there would be a
I-
prayer for quashing of.
IA. Appropriate, IA for bringing on record the in view of the changing situation, Miss so and so, huh? Praise for allowing her to file IA for bringing on record the subsequent development in the case. The prayer is no allowed. List is matter. After
After
After two-
4 weeks.
after 4 weeks. Oh,
Deeply okay.
you're for? Okay, Mr. Name counsel for the respondent number 2 is also present. Okay.
Deeply okay.
Matter number 23,
Yes.
Services are already completed in this matter.
Hmm?
Services are already completed. On last occasion, court have ordered to serve the extra copies. We have.
Okay, this is what? Criminal petition,
Yes, Your Honor.
question petition.
Yes, Your
Okay. So
Yeah, you receive,
it's a joint petition or on merit?
no, it's just for question, that,
Some-
via this, through electronic media, it
Hmm?
cannot be someone
So-
or
Challenging the summon.
Someone other.
Yes,
for
Someone
appearance,
in what?
for appearance before.
Someone issued by whom?
police. IO.
IO.
Yes, OC have served the petitioner.
In connection with what case?
It is a money
Minute, just a
related to
minute,
money.
Just a minute, huh? Okay, someone under section 35,
Yes,
3 of BNS and BNSS.
That is corresponding to 41A of CRPC,
Corresponding to 41A.
capital A of CRPC. Case is not yet been registered. Therefore, there is only
GD entry.
GD entry only. And,
So why you are challenging?
actually the petitioner received through the WhatsApp. So it's against the provision.
Let's take some sense.
actually, this WTM message, which they are challenging, is only a communication between one OC from Nahalagan to another OC, Teju. Because this required person is staying at Teju, and a complaint is made before Nahalagan OC. This person is only required for inquiry purpose. Because case was not registered, so there is no investigation.
So, just a minute, yeah, what have you annexed in your petition? This is the printout of the notice served upon you through WhatsApp.
Yes.
This I.
No,
it's a one.
WT message.
WT message.
Yes.
So that is not a WhatsApp message then.
It's a general practice that one station to another
Yes.
station,
That,
WT
is-
message.
that can be. What is this standing order which you have annexed as annexed to?
It is a it's a order issued by Honorable Supreme Court. Here it's mentioned about this case which
No, no,
is-
you have received this notice
yes,
through
through WhatsApp.
OCPS Teju,
Yes, through WhatsApp.
No, no,
through WhatsApp only.
through WT message. It's in page
WT
17.
message, it appears.
Page 17.
Yes, but sent through the WhatsApp.
Not physically informed.
No,
Who has printed it? It's you.
Your Lordship.
Okay. It was accompanied along with some message.
Yes, they didn't send anything else, just WT message. And when we went to police station for the complaint filed by the complainant, the police officer didn't serve us that complaint.
Where is that application that you're seeking copy of the FIR against you?
We didn't annex here because
No,
they
you
didn't
have to
accept it.
annex. I
They
think
didn't accepted the application even, and they denied that they will even receive the application. We went thrice there in police station. First we went to OC. First we went to IO, then we went to OC. Both of them have denied.
no, it's not possible.
No any record pertaining to that appearance.
Through the same WhatsApp you send then.
No, no, we went physically twice in the Nahalagan police station.
Now you acknowledge the application by in the register.
Actually,
They used to mention register
yes,
for any application,
yes,
anything.
we went
FIR
there.
or
We
whatever.
went there in the staff. Then staff said that because this is complaint made by the complainant, so you have to go to the IO. Then we went to IO. Then IO said that I can't permit, so you go to OC. Then we went to OC, but OC also denied. So that is the difficulty we faced. Then we came to the Your Lordship.
Who lodged otherwise complaint against you?
It's
You are apprehending your arrest. That means,
it's mentioned in the
Isn't it? Isn't it?
in WT message. It is mentioned his complaint.
see, you appear before the IO of the case.
Yes.
Isn't it?
Yes.
Isn't it?
Sorry, Your Lordship.
No, for asking,
Yes.
seeking a copy of the FIR, you went to the police station, isn't it already?
Yes.
You have visited, you have met the
No,
IO. also?
council has went there.
Oh, council.
No, not the petitioner. Because first petitioners want to know what is in the complaint.
No, what's wrong? The council, if the petitioner goes and asks for the copy, because here in any case, you are not going to be arrested. And if you are apprehending your arrest, then you see, you can, because since you have, you said that you have already applied for the copy of the FIR and annex the FIR also.
No, we went to ask for the copy, but they said that first he have to appear. After that, we will give. Otherwise, they won't. We have went there. We have submitted application, but they didn't accept that application.
So that is why I'm saying, in any case, you are not going to be arrested. What's harm in appearing before the police?
We are apprehending the for arrest.
Then you can file the AB. Since you have already applied for the FIR, a
Yes.
copy of FIR, that also has not been given.
Yes.
And then you apply. that you are apprehending arrest in connection with some case, non-bailable offense. If you know something about the complaint, then you state that also, but then the copy was not furnished to you, although we have applied, this is the copy, but this was not even received by the IO or OC of the PS case, and that is why, or direct for the copy of the FIR, then we'll direct for the production of the copy of the FIR.
Yes, exactly.
Your lordship, actually the matter which these officers have informed us is that it is the relating to the money. So usually what happens?
That is why it is a money transaction.
Yes.
You will not be arrested.
Yes, usually what happens is that when there is some difficulty faced, they serve us notice and we give reply. After that, they file money suit. But here they are causing difficulty to the petitioners. It means they have other intentions. So we are afraid that they might take other course.
That is why. So this way, how do we quash?
As per this judgment we have placed before your lordship, it says that they have to serve physically. So wide of initio is there. So we are challenging that.
Let us see the relevant portion. That is of course true. It has to be physically. But then
it's in para 7, page number 8.
But nowadays, I think somewhere in some case, Supreme Court, someone throw the WhatsApp also, probably.
But it is
Yes,
recent
yes,
judgment.
there was a judgment.
But it is recent judgment. It's 2025 judgment which we have placed.
Yes. Permanent service was summoned via the mode of electronic communications, only in those cases where the summons were removed at the court seal. Para 7.
Yes, para 7, we have mentioned that on 22nd he have served, he received the electronic this message. And in para 8, we have mentioned the judgment.
In para 8 means your para 7.
Yes, para 8. Para 7, page number 8.
where have you stated that you appeared before, your counsel appeared before the IO of the case and the OCPS?
It's in para 4. Para 4, page number 5.
Para 4?
Page number 5.
Here you have page number
5.
5. Para 4 is page number 6. You have, I think, double para 4.
Maybe.
See at para 5, page 6 also there is para 4. Which para is para 4?
The petitioner begged to state that since petitioner was not aware of the contents, it starts with like.
There is a repetition of para 4, huh? Have you seen?
Yes, para 6 also.
Maybe,
Page 6 also there is para.
maybe I made mistakes. Beg your pardon.
See, is there any record was called for, any instruction was asked for?
Yes, instruction.
What is your instruction?
The lordships.
Well, what is the problem?
So
sir?
we have communicated with the OC through WT message,
Okay,
but till now there is no response. Their side.
there. Now, obtain instruction because this is unusual. Unusual in the sense he is taking very lightly,
Yes.
and then why he is doing and not even furnishing the copy of the FIR also. And this regarding this also you obtain instruction. We'll take up it in on Tuesday.
Your Lordship, maybe on 10th because leading counsel is out of station.
No problem, no problem. Only we have to see what instruction he has received. Okay?
Yes.
And then otherwise, we will direct. If there is no instruction on the next date, we'll see.
Yes.
Yes, yes. By next date.
Tuesday?
Yes.
Hmm.
There is interim may be continued.
Hmm?
There is interim may continue.
Yes, yes, yes. See, you have to explain the OC or IO. Normally, it is expected that when the accused comes, he is otherwise entitled to a copy. What is the allegation against him or her?
Yes, that is accused right.
And then normally this such notice is to be served personally. Your police station, you are having a human resources, okay? So serve it through physically, or call him or call her, okay? Or register, investigate, and then issue notice.
When I impaired this matter with some other police personnel, this is a usual course of their taking steps by this WT messages.
No, see, the WhatsApp, and that is also not by himself, but through some other police station again. Okay, so WhatsApp and transferred. So could have called also. I have this information. I received this. We need to ask something. The IO could have also straight away called the alleged accused person if he is the accused person, isn't it? But then sending through somewhere WhatsApp as if it is going viral. Who will believe, isn't it? And unless there is some other message, this is from the police station. We do not know. They do not know who sent it, isn't it? So that authenticity has to be at least there.
Yes, but next date I will try to obtain it.
Okay. Harmi Sonam Somo, Lana Counsel for the petitioner, Mr. G. Tado, Lana, the additional PP, submits that. Although he has sought for an instruction in connection with the case from the officer in charge. Nahagaland. However, the same is still awaited. But however, the sought for instruction by his letter dated 6/11/2025. However, the same
Honestly,
as however, the response is still awaited. The response from the or CPS Nahalagan is still awaited. Staff and prays for some more time. Staff. The prayer is allowed. List his matter again on Tuesday. Next Tuesday would be.
Tuesday is holiday.
Okay, now, when then? Then 26.
Yes, Wednesday.
26. Or Monday, 24, okay? Is it okay? Is Nahalagan only?
Yes, 24 because there are sometimes.
26, okay, 26. Okay.
Interim may be continued.
The interim order passed earlier shall continue till then. Okay.
Item number 24.
May I please, my lord? My lord, we have taken steps upon respondent number 2, my lord.
Step of respondent number
2, my lord.
2. Okay. Still awaited.
Still awaited, my lord.
This is also quashing petition.
My lord, cancellation of bail, my lord.
Of cancellation of bail.
Bail, my lord. Granted by the district and session judges, my lord.
Okay, and you are
I am for the victim, my lord.
victim.
Victim, my lord.
Victim filed this application through Learned Special PP or you are for
I'm for the SIT matter.
SIT. It has to come through SIT, I think. SIT has to file.
By their own capacity of file, madam.
Own capacity.
Yes, my lord.
Can it be
Yes, madam.
SIT case?
Yes, no, my lord. SIT case, my lord. They have challenged the legality of the order passed by the Learned Session Court, my lord.
Okay.
Yes, my lord.
Bail order.
Yes, on the bail order, on the merit, my lord. Not on the terms that bail condition has been violated, but on the fact that order has been wrongly passed as per their contention.
Bail is a discretion. What the ground you have taken?
My lord, I have taken grounds that and there are
Unless there is a violation, once bail granted, it's very difficult unless he violates the bail condition. Because bail is a discretion.
Yes, my lord. That
And while exercising the discretion power, just a minute, huh? So where is the
grounds, my lord, in page number 6, my lord. Grounds we have taken, my lord. Para 8, my lord.
this you have come under what provisions?
For 483 clause 3, my lord. Subsection clause 3.
Cancellation.
Cancellation of bail.
That is why I'm saying cancellation has to come through the public prosecutor, PP only. Now you cannot be the respondent here. Can you? Can it be?
Yes, ma'am. Actually, we are supposed to be pro forma respondent, madam. We are investigation authority, madam. And this accused person has been made as a party also.
It has to come through, I think. Where is the 483? Let us see. BNSS. Okay. Okay. So at the time of hearing the bail application, you were also present.
Yes, my lord, I was present, my lord.
Let us see the ground once.
Page 6, my lord. Para 8, my lord.
What is the allegation against the accused?
Abatement of suicide, my lord.
Abatement.
Abatement of suicide.
See, abatement is very difficult again. Okay. That according to you, while considering the bail application, the Learned Trial Court has touched the merit of the case.
Yes.
What's wrong in it, supposing even if it touch also? But in a trial, it's not a conclusive. In a trial, you can bring it. Has he by any way violated the bail condition?
No, my lord.
Then it will be difficult. Once bail granted, he has exercised the discretion.
My lord, in that case, my lord, matter
in-
matter will fix on Thursday, my lord, so that the leading council can make his submission, my lord. Thursday, my lord. On
Next Thursday.
Service is still awaited.
service.
Service is still awaited. Okay,
Awaited.
then, okay, in that case, Mr.
M. Ratan, my lord.
Ratan, counsel for the petitioner. Also had Mr. Kordu, Kordu, special PP for SIT. Staffer. Office note dated 19/11/2025 reflect that the service upon the respondent number 2. The service of notice upon respondent number 2 is still awaited. In view of the above, let this matter be listed after.
On Thursday, my lord. 27th. 27th, my lord. Next week.
Still awaited.
Is still awaited, my lord. My lord, let the notice may be returned, my lord. We will wait for the notice to return.
When the step was taken?
Step was taken on 17, my lord.
17.
Yes, my lord.
So Thursday would be
27, my lord.
17, 27. Is it? Is a through postal?
Postal, my lord. Through register AD, my lord. It is
Through
nearby only, my lord, in Itanagar, my lord, the address. Respondent number 2 is residing at Itanagar, my lord.
We'll say after a week, okay? Please, after a week, okay? At least register. It's very difficult.
Yes, man.
Earlier, to reach the same sector, because it has to go through. It doesn't go straight away from here to here. It will go somewhere in the headquarter and then come back. So it takes time. Yes. Okay.
27, my lord, it will be 1 week only, my lord. 20 by next Thursday, it will be 1 week only, my lord.
1 week.
Yes, my lord.
After a week, I said.
Deeply honest, my lord.
Obliged.
Item number 27.
Oh, there is a hearing. I thought it's finished. Criminal appeal.
Yes, this is jail appeal.
Jail appeal.
Yes.
Just a minute. Just a minute. I thought it's finished. So the paper book is complete now.
Yes.
You have received, okay, earlier it was, you complained that it's not, it doesn't contain the entire, including arrest memo, etc., seizure list. Now it's, you have received
Yes.
all those. Now parties are ready for hearing.
Yes. Otherwise it's ready.
Okay. Just a minute. Earlier heard? No, it's the
No.
first time.
First time.
Okay. Which PS case?
This is
Which which court?
Pasigat PS case.
Oh, Pasigat.
Yes.
Okay, so convicted for offense?
Under section 376(2), read with section 6 of POCSO Act.
For sentence for?
10 years, rigorous.